shareholders at home. You're welcome today to another interesting episode of Insights from Exinetas Legal. Today we have a distinguished personality with us in person of Barrister Itayo Ogunyemi. Barrister Itayo Ogunyemi is a legal luminary who understands corporate law, in depth. He deals with a lot of businesses, startups, medium-sized, big-sized businesses. He litigates, corporate matters, and he understands, the rudiments of company law. So, Barrister Itayo Ogunyemi, you're welcome.
Thank you. Thanks for having me
today. And today we'll be talking about an interesting concept under the company law, which is the minority shareholding. What's the concept of minority shareholding? Who are the minority shareholders? And what protection does the company law offer them using Nigeria as a case study? So, Barrister Tayo, you're welcome again.
Thank you for having me.
Yes, so
I'm happy to be here.
Yes, it's nice to have you. So I call him Barrister Tayo, and we're going to go straight into business this afternoon. So who are minority shareholders?
Okay, so to start with, maybe it's important to understand the context of who shareholders are. There is the idea that when you register, when a company is incorporated, when a company comes into existence, it's like a baby, and it has a life of its own, different from those who gave birth to it. So that would then presuppose as well that the best that anybody can be in a company is a stakeholder and not the owner. So the shareholders usually are considered to be the co-stakeholders, the stakeholders of the business. And when somebody is now considered to be a minority shareholder, it means that the person's stake in the business is not up to half of the total stake of the business. And of course, this is it from the context of what the law says. I usually would also like to make reference that sometimes you have to put into consideration the limitations that come from private arrangements, like shareholders agreements, like memorandum and articles of association, which are not necessarily invalidated by the provisions, by what the law itself makes provision for. So when you put those things in context, you would find that even sometimes someone can, on the paper, have more than 50% ownership, stake in a business and still be considered to be a minority shareholder just by reason of agreements that are also binding on parties. So usually, this is just a call to everybody that it's important that you check the other agreements that governs the stake, the ownership, the holdings of the business that you are investing in.
So basically, it's not an issue of the fact that you might have 52% of the shares and still be a minority shareholder by virtue of the shareholders agreement. That's what it means.
Yes.
And you might have 30% shareholding and still be able to make considerable decisions.
So we can also give examples. So for instance, sometimes you would have agreements that even will state that so persons have the right to nominate on, and from the nomination this is done, that is done. At the end of the day, it limits the even if you have the 99% of the stake of the business, it now limits your power. It limits that ability to influence things within the business. And one way or the other, it's more like one is now reduced to the status of minority shareholders as envisaged by the law itself.
Okay. Yeah, that's quite interesting. So a lot of times, so it's relative based on cases. Okay, good. But when it comes to maybe people that are quote and unquote minority in terms of their shareholding, does not really give them the majority influence in the company. What does the common law say about the protection that they can be offered? And this will lead us to I want you to clarify for us, there's a rule under the common law that's called the Foss and Harbottle rule. What does that rule say, and how does it help with protection of minority shareholders?
Okay, so first we start with the rule in Foss and Harbottle, which is a decided case, by the way, to the effect that a company has its independent existence. Now, to make this easy for you to relate with this conversation, it's as good as saying, hey, you invested XYZ amount in a business, and now the business, things are happening, and then you're getting emotional about it. That, look, since I invested this amount, I have the entitlement, I have the right to influence things that happen, especially because my money is there. I mean, it's just natural to think that way. But what the rule in the Foss and Harbottle is saying is that the company has its own independent existence. The company can do things for itself. The company can sue for itself. The company can protect itself. It's just natural babies that you say, this baby doesn't know what he or she is doing yet. But when a company is given birth to, the company is assumed to become an adult at birth immediately and has its own independent existence. But again, because if that position of the law is now spread at large, such that it becomes a casting stone, it will do injustice. And how will it do injustice? At the end of the day, you would agree with me that companies, even though are artificial persons, they do not have a brain of theirs.
Because they are
driven by people.
Yeah.
So at the end of the day, it is still people that make the decision. But these people are clothed in the garment of the company. At the end of the day, it is still some shareholders that would vote, or it is still shareholders that will vote, and the majority eventually would have to now, it is the decision of the majority, depending on the kind of subject matter, whether it's a vote that has to be special resolution or something. It is the decision of the people that are in the majority that would take the day, carry the weight. So the rule then says, the exception to the rule in Foss and Harbottle then says that there are situations that might arise where minority shareholders, people that may not by the instrument, the tool of their votes, influence things, they should be allowed to take the stand and challenge certain activities, whether activities that could amount to fraud, to defrauding, fraud against the business, whether it's some situation where the directors are abusing their fiduciary position for their own benefit, and many other, even whether it's a situation where the minority shareholder now is the subject matter, and he or she is the decision is going to be detrimental, especially or particularly to that minority shareholder, and a number of other situations. These are things that the law envisages and then says, in this kind of instance, you, even though being a minority stakeholder, you may be given the opportunity to influence what then happens within the business.
Okay, so they can bring an action against the
Yes.
company. So in that case, they'll bring an action against the company, or would they bring an action against the directors or the majority shareholders?
It actually depends on the subject matter. It depends on the subject matter. There is something that is called, you can do a personal action, you can do representative action, and then there is something that is called derivative action, in which you are asking for approval from the court, from constituted authorities, to stand in the shoe of the company to bring an action on behalf of the company. So it really depends on the subject matter that is being looked at,
Okay.
and the kind of claim at the end of the day that is being looked at. You are doing a derivative action. Let's say, for instance, that now the company may not be able to speak for itself, and the brain, which is the board, are not willing to do anything about it, and you have a tangible basis, sufficient evidence to show that, look, this company has to take steps in this situation, then you may be looking at what is called a derivative action, where you will be seeking for the approval of the court and constituted authorities to take that action. And for, again, the fact that even when all of that is done, with that kind of approval, it will now mean that it is the company that would, at the end of the day, be responsible financially for those steps that have been taken, because you've gotten an approval to take those steps on behalf of the business.
So you can take those steps even if you're a minority shareholder?
Yes.
If you bring that derivative action?
Yes, but you have to now seek the permission, so that people don't just wake up overnight and say, oh, I'm a minority shareholder, but I know my rights, and if you violate my right, I'll jump to court and all of that. There are processes to all of these things. And that's why it's important for you to also seek the advice of your lawyer, seek the counsel of your lawyer, so that you are properly guided on how to ensure that your right in that business is protected. You mentioned something a while ago about how annual general meetings are done, and some people make decisions, and then even you
just see the report.
You just keep seeing all the reports. You see the newspaper reports, you see the television reports, you see the radio jingles, but all you are hearing are those. When you see all the millions and the billions, and you wonder where are they going to, right?
So the majority controls. The majority shareholders control the company.
So things like that happen, and we're not saying that just because minority shareholder, there are things you can do, you jump at it, and you don't follow the procedures. There's usually procedure for everything.
Yeah. Thank you so much. Well, I think it's very interesting because, there's good essence in discussing this topic, because the ideal, I'll say 70% of the populace are in the minority shareholding class.
Especially when it comes to public
companies. And people also have to understand, even though, yes, I invest maybe let's say 15% in a company or 10% in a company, I should not just watch the company die, because you put your money there. So the law offers certain protection for minority shareholders to come in, and that's why we're discussing this topic, and it's actually very interesting. So what are the exceptions, to this ruling in Foss and Harbottle? There are exceptions, and what are the reliefs under the Company and Allied Matters Act given to minority shareholders?
Well, so to start with the exceptions, one of those exceptions is in case of fraud. It's a case of fraud. It will be fraud committed against the company, especially fraud committed against the company. Then another thing could be where something is excessive. Now, the lawyer's language is ultra vires, and that would mean that it's above the scope of power of the business, and then maybe the majority are pushing for something like that, and then you, as part of the minority, you know that, look, this is above the scope of authority, is ultra vires the powers of the business or something. That's another very crucial basis. And another point again is, let's say, a situation where the board have come together and there's an abuse of their fiduciary position for their own personal benefit, for which they are not even willing to do anything about, and the majority shareholders too just sitting by the fence on, maybe because there's also an extended benefit to them or something. So when you see all of these things, they are pointers to the fact that you can take steps, and I think there are still about a number of them. Another situation could be, let's say, other than fraud, when something is also illegal. When an act is also illegal, that's another basis for you to take step. And just as I mentioned earlier on too, if you know that your interest is the subject matter and is targeted at you, and it gives you that privilege because you know that you are the subject matter. It's like a targeted situation, and you can then leverage on that position of being a minority shareholder, that, look, if you are not given the opportunity to stand up and be heard, then the majority would vote and they just kick you out. I mean, let's assume a situation where by no known rule, the general meeting was just called for the sole purpose of kicking somebody out and collecting back the shares. I mean, things could happen, and these are practical things.
Happens, actually.
These are practical things that happen. So you could actually run to the court and then leverage on the position, the provision, what the law says, and then use that as a basis to seek for justice, whether for yourself, in your status, in your capacity, or even for the love of the business, in your status as somebody that is a stakeholder in the business. So you might be asking the court to restrain them. Now, a restraining order would mean that the court should halt, should stop them, should stop the subjects. So the them here could be the board, depending on the subject matter, could be the board,
the majority shareholders,
the general meeting where the majority shareholders are going to do stuff. And when it comes to protection of your right as a minority shareholder, it's not something that you sleep over. You have to also be very fast. There is this maxim that says equity aids the vigilant. So you have to be very timely. You have to be very fast in ensuring that you seek redress as soon as possible. So you don't sleep over your right. You have to be very fast. Because imagine that a meeting is going to hold by tomorrow, and then you are still drinking and whining away time today, saying that tomorrow morning I will see magic that will happen. And you have today to have taken step to ensure that meeting does not even hold.
What if a situation where the minority shareholder does not even have an idea that the meeting is going to hold and is actually going to be against his own rights?
So in that situation, what the law provides by default is every member ordinarily should have a right to notice of meeting. So the minority shareholder in that situation can actually it can be a course of action, a basis to ask the court to compel the company or the general meeting to be set aside as being invalid because proper
the due process
was not followed. So you could ask for setting aside, you could even ask for investigation into the activities of the company, which could include auditing of the books of the company. Even the court can compel the regulatory agency, which is the Corporate Affairs Commission, to look into the affairs of the business. And sometimes, if it involves a public company, it could also mean that agencies like SEC, Securities and Exchange Commission, can even be brought into the play. You can get compelling orders, and on and on and on. These are things that you can have access to.
Okay, that's very interesting, and I think also part of the exceptions. If an act is supposed to be done by ordinary resolution, it was done by special resolution, or it's supposed to be done by special resolution. It's not done by ordinary resolution. A minority shareholder can bring an action in that case, and where also the interest of justice, demands that an act has to be done, then the minority shareholder should not sleep on the rights.
Yeah, that's it.
Yes, definitely. So you mentioned, I think, what are the reliefs? I think when we're talking initially, we're talking about the actions. Can you explain in detail what actions, the minority shareholder can bring, as a relief that is recognized under the law?
Okay, so you can do what is called a personal action, which it is you now going to court. As mentioned earlier on, this also will depend on the peculiarity, the nature of the subject, the basis of the action. So it could be a personal action where it's like you against the company or something, or it could be what is called a derivative action, which is you seeking for permission to bring an action on behalf of the business. And interestingly too, even minority could come together for a class action. So but at the end of the day, it's always important for you to consult your lawyer so that you can be properly guided on how to go about this kind of action when you think or you feel that your right within the business has been infringed, and you are almost helpless just because of the fact that your vote does not hold water, does not carry weight in the transaction or in the subject matter.
Okay. Yeah, so a representative action, does that count like a class action?
Well, so representative action could be put in the context of you showing up in a representative capacity. So, which of course will be different from we're all coming together and we're the association of the minority shareholders.
So what about the 5% shareholding can come
which does not still hold weight at the end of the day.
Why there are like 5,000 shareholders in a public limited liability company? Can't they merge to become a majority control?
Well, at the end of the day, if they come together and they merge and their votes, they may not have a basis to say they are doing any action, because once there can be, this is politics at the private level.
Yeah.
It's politics at the private level, and this happens a lot. This is part of corporate governance. It happens a lot, where the shareholders would have done their campaign privately, their lobbying, and then they show up on the day of election, and those that ordinarily supposed to be considered as minority, they've been able to pull their weight together, and through their votes, they're able to dictate the pace and how the business should go. So yeah, these are practical things that happen, and it's interesting. So I do not want to delve away from the conversation. But really, if you're seeking to learn lobbying and politics, it starts from the private sector.
Go and invest in a
company and deliberately make it a deliberate thing to be actively involved in that company.
Yeah, you're very right. Actually, I think the politics at the level of company is really, in fact, is so high. It's so high. Because you see meetings before the meetings before the AGM.
Caucus meetings, this meeting, that meeting.
All in a bit to control decisions
and
the outcome of decisions in the company. So thank you so very much. Before we go, I just want you to shed more light on the derivative action that minority shareholders could bring.
Okay, so for the concept of derivative action, it would mean that let's assume that there's a situation that has occurred, and ideally the company is supposed to take steps, but the board are not willing. The board is not convinced, and the majority shareholders are also not using their position to influence things. But of course, you and I know that the board, when it comes to the driving of the business, they have the last say when it comes to that. So if you, as a minority shareholder, you don't look at the situation, you know that there are evidences, there are things that shows that it's reasonable for the board to have acted, you can apply to the court for approval. Another way you can look at it, lawyers would understand this better, but for those of you listening that have followed criminal matters most especially, you find that what the law says is that criminal matters ought to be prosecuted by the state. But you can seek for private fiat. You can seek for permission as a private prosecutor to prosecute matters. So it's a replica of that. It's something very similar to that. That look, the default position is that it is the board that would pass a resolution and say we are instituting this case because as the board, as the brain of the business, we see that this is important for us. But then the drivers are not now doing the needful. And you are saying that, look, I need an approval to do this in the interest of the business.
So the minority shareholders will bring the action in the name of the company.
Yes. And when that kind of approval is granted, it would also now mean that the company would also be responsible financially
for the legal action.
The action that was brought. So, and this is where sometimes people miss it, in the sense that while this kind of request is done, sometimes they leave out the request for the company has to be responsible, and even when it's not left out, the place of accountability is not there. Because I've seen derivative actions lead to the end of the business, where now leave was granted, and then it becomes a political game of you have to account how much was spent, this and that. Well, so the impression that is given at the end is this person used the opportunity to make money, siphon money, this and that. So but things are getting more organized, and that's a good thing. So it still boils down to the fact that you need proper legal counseling, proper legal guidance for you to ensure that you get the best of what a derivative action can do in saving the business and in protecting the integrity of the business.
So thank you so much. So invariably, if the minority shareholders bring the derivative action, they still need the board to ratify that decision.
Oh, so they do not need a board, using so to speak, because now this is going to be an approval that comes from the court.
But when it comes to the legal fees, in terms of the company,
so once there's an approval, which is why I said it has to be detailed. So you must what you are presenting before the court must be detailed enough to ensure that you do not leave yourself to the mercy of the board again. Which is why I said it's very important that you engage your lawyer that understands the context of corporate practices and how this whole thing plays out in court, so that at the end of the day it doesn't leave that loophole for some conflicts which might at the end of the day even lead to the death of the business.
So thank you so very much. I believe we've learned so much today. And in recap, we've spoken about minority shareholders, who they are, the actions they can bring, what exceptions to the rule, under the common law, which invariably is also instituted under the Company and Allied Matters Act in Nigeria, as amended. There are instances where somebody even that has 3% shareholding in the company could approach the court to bring an action if it's something that is going to be detrimental to the business, or maybe it's something that is affecting his rights as a person, or maybe an injustice is being done, or the board, they are doing certain things that are against their fiduciary obligations to the company. So definitely there's always exceptions to every rule under the law, and the fact that you only have 3%, 1%, 10%, 15% of a shareholding in a company does not mean you are relegated to the background. It has to be established. You have rights. The law has given every shareholder a right. Your 1 naira, your 2 naira, your $1, your 2 cedis counts in every company. The only thing is, don't bring actions in bad faith. A lot of people bring frivolous actions, and in practice, that is being thrown out really by the courts. So today we want to thank you, Mr. Etayo, for coming on Insights from Regulators Legal today. Thank you so much for enlightening us on minority protection. I believe we've learned so much today, and it's really been insightful. And especially even this derivative action, and knowing that if you bring derivative action in the name of the company, the court grants you the action. You are not the one that's supposed to be responsible for the legal cost. It's actually the company, but a lot of shareholders leave that out. So you need to engage proper legal advice, from corporate lawyers, before investing, and know where to invest. So hopefully you will call on you again, and we believe you answer us to come and share again with us some interesting aspects of commercial law. Thank you so much for coming. We appreciate it.
You're welcome. I'm privileged to be here, and I follow the event and the programs very well. I must say that you're doing a very fantastic work, and in helping people out there. Thank you for having me, and I'll look forward to being here again.
Yeah, thank you so much. Thank you. So we call it a wrap today on Insights from Exmeters Legal. Have a lovely weekend. See you next time. Bye.